Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome back to the autumn season for our podcast series. I'm conscious I've done fewer podcasts in the last couple of months, and that's been caused partly by the volume of work and partly because I've been away quite a lot. So anyway, there's a real back to school feel about all of this now, and we're resuming normal service on the podcast. And after 6 music festivals across a couple of months and some holiday thrown in, I probably think it's about time to get back to work. Anyway, I wanted to pick up 3 cases that have come up in the last 6 weeks or so. First of all, we have an update on a case involving collective bargaining and whether the employer was entitled to make an offer directly to its employees. We've then got a really useful case on what happens where an employee covertly records meetings with the employer. Can an employer then use the fact of that covert recording to bring about the dismissal of the employee? Finally, and as part of our ongoing theme of cases that dealt with privacy issues in employment tribunals, we have a case involving claimant's right to privacy and whether or not the claimant could block a tribunal decision being put on the public register. Please don't forget the podcast is available via iTunes on the Mayer Brown website or YouTube, and the Twitter feed Nicholas Robertson at Nicholas ROBER11, and there are links to all the cases posted out too. We're also on Spotify, Google Play and Yahoo as well. So, first up, Costello UK and Dunkley. We've looked at this case previously on the podcast, but it's now gone to the Court of Appeal, and the Court of Appeal have taken a rather different approach to matters, which will, I think, be a significant relief for employers. The legal background is that Section 145B of the Trade Union and Labour Relations Consolidation Act 1992 prohibits employers from offering incentives to employees to bargain directly with the employer on an individual basis rather than bargain collectively. Section 145B itself states that it is prohibited for an employer to make an offer directly to an individual who is a member of an independent trade union, and that union is either recognised by the employer or is seeking to be recognised by the employer, and the employer makes the acceptance of its offer to the individual conditional on that individual agreeing that the individual's terms of employment or any of those terms will not or will no longer be determined by collective agreement negotiated by or on behalf of the union. The employer has to have the sole or main purpose of achieving that result in the offer that is being made. So, the key parts are you have to have a recognised trade union or a union seeking recognition. There is an offer made directly by the employer to an employee, and the sole or main purpose of the offer is that the employee's terms will not or will no longer be determined by collective agreement. Just to finish on the statutory framework, there's a mandatory award which is payable wherever there is such a prohibited offer has been found to have been made. The background facts in this situation are relatively straightforward and not exactly unheard of. The employer, Costello, had a recognised trade union. There was a pay round. In return for a particular payoff for 1 year, Costello wanted employees to agree that they were going to give up certain rights in their contract. This was rejected in a consultative ballot that the union put out to the staff, and then there was deadlock. And on 2 separate occasions, Costello wrote directly to the employees inviting individuals to accept the relevant offer. Eventually matters were resolved by agreement, but employees then brought claims arguing there had been a breach of Section 145B. They said, in brief, that the effect of accepting Costello's offer would have been that that particular term would no longer be determined by collective bargaining, because they would have agreed it directly with the employer. It would instead have been determined by one-to-one bargaining. To that extent, then, the offer was in effect an inducement to agree that this offer would not be negotiated collectively. Costello, in contrast, said they were perfectly happy to carry on recognising the union for all purposes. They were simply attempting to break the deadlock in relation to this pay bargaining round. Both the Employment Tribunal and the EAT agreed with the trade union, and as a result, Costello was looking at a fairly significant compensation payment because it was a mandatory payment. Kostal appealed to the Court of Appeal, and the Court of Appeal took a rather different approach from the Employment Tribunal and the EAT. They said that the legislation was designed to prevent two situations. In the first, the employer offers an incentive to employees to prevent a trade union being recognised. In other words, employees will be paid to agree they will continue to bargain on an individual basis. Alternatively, the offer might be made by an employer to obtain the withdrawal of the recognition of a trade union's right to negotiate on a collective basis. Both of those results are prohibited by the legislation. Instead, the Court of Appeal said, there was no basis for saying that legislation was intended to apply to the third type of situation, which is the one that had arisen here, i.e. there's a deadlock in collective negotiations and the employers write directly to the employees, inviting them individually to accept a particular offer. I have to say, I think the Court of Appeal's reasoning is pretty convincing. First, they said that if the trade union's interpretation of the legislation was correct, it would give a veto to the trade union in practical terms. If an employer with a recognised trade union is not allowed to go directly to the employees on a particular offer, then the union can always veto making offers. However, on the other hand, if the company's interpretation was correct and it can make offers directly to the workforce, this did not emasculate the trade union. If the employer went directly to the workforce on a particular occasion, and the trade union could always initiate a ballot for industrial action if it and the workforce felt sufficiently strongly. The alternative interpretation would either be unworkable, the court said, or would simply produce stalemate. I think a lot of employers will breathe a sigh of relief about this case. In principle, the idea that a trade union can prohibit an employer writing directly to its own workforce, inviting them to accept a particular offer, whilst the employer is clear that it is going to be continuing recognition of the particular trade union for collective bargaining purposes, seems to be a very surprising conclusion. It's possible that the case may go up to the Supreme Court, and of course the factual situations that might arise can be infinitely varied. What happened if an employer almost immediately went directly to the workforce? What happened if the employer did it every year, for example? Does that start to, in practical terms, move away from the factual situation here in Kostal? The further point then is whether an employer faced with this sort of situation in the future might be able to sidestep this whole line of attack. The issue is whether or not the offer is designed to achieve the end of collective bargaining. Even assuming that it could apply to this type of situation, I don't see that there's anything in either of the two judgments of the lower courts to stop an employer saying to employees, I'm going to carry on negotiating with the union, but here is an offer that I wish you to accept, subject to that ongoing negotiation. Clearly, in that subsequent and ongoing negotiation with the union, the employer may be not minded to make any concessions, but I think they would have made it quite difficult for a trade union to say that the offer to individual staff was intended to end collective consultation around the offer, even in relation to those particular terms. In any event, the Court of Appeal has given a clear and firm ruling that where there is a stalemate, the employer is able to go directly to the employees, provided it is clear it is going to be carrying on recognising the union and bargaining with them in the future. I think if I was acting for an employer in this situation, I would be cautious, as I say, about trying to go to the workforce too soon. Otherwise, it could be portrayed that the employer is in truth trying to circumvent the collective negotiations. But subject to that point, I think the legal position has probably gone back to what we always understood it was, i.e. the legislation was designed to deal with the two separate scenarios identified by the Court of Appeal and not the third scenario identified by this trade union. So that's Kostal UK Limited and Dunkley. Next up, Phoenix House Limited and Stockman. This is a really interesting case dealing with a practical point for employers today. What is the position with an employee who covertly records a meeting with the employer on his or her phone, say, and then tries to use that recording in a subsequent tribunal claim, let's say, against the employer? Factual situation here was pretty much typical of the circumstances in which this sort of problem can arise. The individual worked for Phoenix House. There was a job restructure. There were problems around finding alternative positions for her, and the individual moved into a more junior role, but clearly working relationships were strained. She was then summoned to a meeting because there was a conflict in the working relationship, and she covertly recorded that meeting with HR. She did not say anything at the time, or indeed immediately after the meeting, about what she had done making the recording. There was then a grievance and a formal process, and at the end of the formal process, she was dismissed. During the tribunal process, it then came out that she'd made this covert recording. Now, dealing with the legislative context for a second, because as I'm going to explain, the employer lost its case at the tribunal. The employer pointed out that the tribunal has the ability to reduce both a basic award and a compensatory award, and to make a so-called Polke deduction. Basic award can be reduced or cancelled altogether if the claimant's conduct before dismissal would make it just and equitable for them to take that step. There's a wide discretion. Compensatory award can also be reduced, but only where the claimant's conduct had contributed to the dismissal itself. Finally, the tribunal has the power to reduce a compensatory award on the grounds that if the claimant would have been dismissed by the employer fairly within a short period after the allegedly unfair dismissal, then their future fair dismissal, hypothetically, should be taken into account in calculating compensation. The tribunal gets to make a realistic assessment of the true loss suffered by the employee rather than giving the employee a windfall. So if the employee would have been fairly dismissed a month later, the employee, in normal circumstances, wouldn't have any loss attributable to an earlier unfair dismissal beyond that 1 month period. Well, here, as I say, the tribunal found that the dismissal was unfair and that there had been a breach of the whistleblowing legislation, and that's why we were into compensation. So the tribunal awards compensation, and the employer appealed and challenged the way in which the employment tribunal had dealt with the issue of covert recording when it came to compensation. Obviously, the employer couldn't rely on the fact of covert recording to defend the liability in the case because it wasn't aware of that until after the employment had terminated. But, as I've explained in relation to the legislative framework, that does not prevent a tribunal taking into account what has subsequently become apparent in calculating compensation. Well, here, the Employment Tribunal, having been made aware of the covert recording, what the employee did, when awarding compensation for the successful unfair dismissal and breach of the whistleblowing legislation, had only reduced the claimant's compensation by 10% for the covert recording. The tribunal said the claimant had not made the recording for the purpose of entrapment. In other words, she had not sought to try and provoke the employer's witnesses into saying something unfortunate whilst they believed they were speaking privately. The claimant's explanation was that she had concerns about what the nature of the meeting would be and felt the best thing to do was to record it so that she had a record of the meeting. The employer said the covert recording, however, was a clear breach of the duty of mutual trust and confidence she owed. It was dishonest. In the circumstances, they said they would have dismissed as soon as they found out about this. They also felt the claimant's purpose was rather more sinister and that, in effect, it was part of her agenda to entrap the employer's managers. The EAT disagreed with the employer. They make the interesting comment that in the past, covert recordings were much more difficult to undertake. Therefore, it was much more likely that they were being obtained for inappropriate purposes. However, given that many individuals now carry smartphones so that recording is much easier to undertake, it's no longer necessarily the case that recording is being done for an improper purpose. The EAT certainly agreed it would be good practice to tell parties that a meeting is going to be recorded. The EAT, however, declined to say that it was necessarily the case that making a covert recording breached the duty of mutual trust and confidence owed by the employee to the employer. The employee might have legitimate concerns. There might be a dispute, a disputed account as to what happened at the meeting, and recording might well help there. The employee might want to take subsequent legal advice, and an objective record of what happened at the meeting could assist. The EAT did comment it might not always be desirable to record a meeting. A lengthy transcript of a recording is probably less helpful than a shorter written note summarising the meeting. And they acknowledged that the fact of a recording being made might also inhibit parties from talking frankly about matters for fear of having been misquoted or things being taken out of context. However, the long and the short of it was that the EAT decided the Employment Tribunal had come to a decision it was entitled to come to, and therefore the EAT did not interfere with the relatively minor reduction in the damages for the employee's covert recording. I am sure many employers will be very concerned about this. I'm perhaps less concerned about this and broadly think the EAT is right. It's clear that if the evidence is relevant in a recording, it will not be excluded simply on the basis that it has been obtained without consent. A recording may be excluded if it's been done improperly. I remember there was one case earlier where an employer's disciplinary panel was covertly recorded in the room after the employee had left the room, and the recording was about the panel debating its reasons for the decision it was going to come to. Then it was improper for the employee's covert recording to be admitted into evidence. But as a general rule, we don't have a principle that says evidence obtained without going through the proper channels is necessarily excluded. Secondly, in my view, if an employee would be permitted to have someone present taking notes at the meeting, or is entitled to have the notes of the meeting afterwards, is it really so different to have an employee openly recording a meeting? I don't think so, although many employers I've spoken to dislike the idea intensely. Beyond that, therefore, whilst I can entirely understand that employers may feel aggrieved that employees are covertly recording meetings, I think it's less of a sin in circumstances where the employee could legitimately have taken a note of the meeting or had a colleague present as a note taker. There are two further points. First, the AT commented that it was unusual to see covertly recorded meetings, or covertly recording meetings, I should say, being on a list of gross misconduct offences in a contract. They said it was possible that employers might now look to add those in. However, just by way of reminder, if something is included in the list of potential gross misconduct offences, it doesn't mean that it is necessarily gross misconduct when it happens. The tribunal can still take a view as to whether or not a reasonable employer would have dismissed for such a matter. Finally, we've advised on cases where we've been concerned that employees were trying to record meetings covertly in circumstances where it would not have been appropriate. The employee might have done this so that they were being aware of what was said in the room when the employee and their advisor, let's say, was out of the room, for example, but the employer's side is still in the room discussing matters. I think sometimes covert recording may not be for active use in tribunal proceedings, but maybe just simply to find out what's going on. I think it's now sensible practice where an employer and employee have a meeting, and the employer's side will discuss matters directly after the meeting when the employee's side have left, to have that discussion take place in an entirely separate room. Call me paranoid, but it's probably prudent, I think. Anyway, that's the case of Phoenix House Limited and Stockman. Final case, L and Q Limited, which at the AT stage went under the name of Q and L Limited, just so you know. Anyway, this is a Court of Appeal decision which we can deal with relatively briefly, although I think it's an important point. The claimant brought discrimination claims against a former employer for unlawful discrimination, disability discrimination, victimisation, etc. And the Employment Tribunal agreed that the hearing for these claims would be held in private. It also agreed that witnesses and the parties would be anonymised and that the tribunal judgment would not be placed on the public register. The issue at the Court of Appeal stage was whether the Employment Tribunal was able to do that, and if so, whether it was proper for it to do it in relation to this case. Legal framework is that there is a public register of tribunal claims and that all judgments end up on the public register. This is also online. Claimant argued it was appropriate for the tribunal to avoid placing the decision on the register, and that furthermore, in addition to the anonymisation redactions identified by the Employment Tribunal, the nature of his disabilities and two specific incidents involving those disabilities should be further redacted from the judgment. Indeed, the claimant went as far as to say that if the tribunal could not or would not withhold the decision from the public register, he should be given an opportunity of withdrawing his entire claim rather than having it put on the register. We have no details, of course, as to the nature of his disability, but it's obviously something of considerable sensitivity, shall we say, to the claimant. The Court of Appeal carefully analysed the legislative framework for deciding whether or not the tribunal had the power either to prevent the case going onto the public register or whether it could be redacted extensively in the way the claimant was now asking. Under the 1996 Employment Tribunals Act, there are specific and extensive powers dealing with cases involving national security, and they're clearly not relevant here. Separately, under the 1996 Act, there are sections dealing with evidence relating to confidential information, again not relevant here, allegations of sexual offences, or disability cases. In relation to cases involving allegations of sexual offences or sexual misconduct, the tribunal is permitted to make a restricted reporting order anonymising the identity of parties until the decision of the tribunal is handed down. Similarly, in Section 12, in relation to disability discrimination cases, there can be a restriction of publicity in disability cases where evidence of a personal nature is likely to be given during the hearing. Again, there can be a restricted reporting order. However, overall, under Rule 67 of the Employment Tribunal's Regulations 2013, any judgment is to be entered onto a public register together with any written reasons for a judgment. Rule 50 of the Employment Tribunal Regulations gives a separate power for a tribunal to prevent or restrict public disclosure in order to protect convention rights of any person. The tribunal, however, is directed to give, quote-unquote, full weight for the principle of open justice. And in Rule 50, there is a list of the potential orders that a tribunal can make in appropriate circumstances, including conducting a hearing wholly or partly in private, anonymising the identities of specific parties or witnesses, or a restricted reporting order. Note there's nothing in there in the list about not putting a judgment on the register at all. The Court of Appeal, in rejecting the idea that the tribunal could order a judgment not to be placed on the register, said that there was no explicit power in the rules that permitted the prohibition of publication of the judgment altogether. Previous cases, and in particular the one called Amior, were completely against such approach. Indeed, interestingly, the court went on to say that not only would such a veto on publication be contrary to legal principle, it would also have practical difficulties as well. Individuals, they said, who had had allegations made against them had to be allowed to see the Employment Tribunal judgment in full as a matter of elementary justice. Clearly, those individuals should not be held to be in contempt by telling people what the outcome of the tribunal case was. Ultimately, the court said it was not necessary to go as far as to say there could never, ever, ever be a case outside the field of national security in which an Employment Tribunal judgment could be kept off the register. However, they found it hard to imagine those circumstances, and certainly in this one, they said this case was not it. On that basis, the judgment is to be entered on the public register. The court also went on to consider whether it was appropriate to do the redaction, the additional redaction that about the claimant's disability and the incidents related to it. The Court of Appeal was against this idea too. They said it would fundamentally undermine the understanding of the Employment Tribunal's judgment if those details were omitted. And since the company's witnesses would obviously be given the full judgment, the risk of further embarrassment to the claimant was extremely remote. And they commented that it would be, quote, wholly unjustifiable to have judgments censored in this way, unquote. Pretty powerful language. So, all in all, clear-cut decision in favour of judgments going on to the register with reasons where, in all probability, the furthest that a claimant will get is to anonymise the parties and possibly the witnesses in appropriate cases. However, since the court is very clear that those involved in the case are able to see the full decision and speak about it, unless there's an ongoing restricted reporting order at that point, clearly the principle of open justice carries a lot of weight for the court, as we knew. So, in a nutshell, it seems that outside the field of national security decisions, judgments will be included on the register with reasons, and it's a public register. Given that the register is public, the register of tribunal claims is public, there has been a general consensus that employers might well pay individuals off before claims are actually commenced to avoid seeing their own name on the register. But I think this case shows it goes both ways. Claimants may themselves be very concerned about being identified on a public document as having sued a former employer or the nature of the allegations. And if it goes all the way through to a hearing, they may be very concerned about having personal details available on a public register if they form part of the judgment. Circumstances, it may well be that there are plenty of employees or ex-employees who will have every bit as much concern about engaging in public litigation as employers. I should say that I've seen a short summary of this case at the employment appeals stage. For various reasons, at the time I did this podcast, I couldn't find the EAT judgment on the website, and it didn't seem to be online anywhere. And it was under the name of Q&L, and I wonder if because the anonymisation is still being sorted out, possibly the judgment has been taken down temporarily. But anyway, according to the summary that I have seen, under the name Q&L, the EAT were asked about the circumstances in which an employer was deemed to have notice of an individual's disability. This didn't form part of the decision at the Court of Appeal stage, but as I say, according to the summaries I've seen, the EAT said that if an occupational health professional was made aware of an individual's disability in circumstances where the individual has only consented to the employer being told by that occupational health advisor, simply yes or no, is the individual fit for work, then the occupational health advisor's detailed knowledge of the employee's disability is not deemed to be the knowledge of the employer. I think that's quite an important point, given the prevalence of occupational health screening. I'll try and see if I can follow up on this and see if I can get a full copy of the decision in due course. But I think the point, if I've correctly summarised it, is an important one for employers. So that's the case of L&Q Limited. So thank you as always for listening. Glad to be back. We'll be back in 2 weeks' time. Normal service will continue. Please do let me know if you have any thoughts or comments on the cases we cover in this podcast, or indeed generally. It's always a pleasure to hear from people, especially since we have so little idea who actually subscribes to the podcast. I enjoy doing them anyway. In the meantime, and as always, it only remains for me to confirm that no employees were harmed or otherwise mistreated in the making of this podcast. Thanks, everyone.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.